Good morning, everyone, and welcome to our webinar, Fair Play, Understanding the Unfair Contract Terms Regime. I'd like to start with an acknowledgement of country. I'd like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land. I pay my respects to elders past, present, and I recognise their continuing connection to our land, waters and culture. I extend my respect to the Aboriginal and Torres Strait Islander peoples here today. I'd like to start with some basic principles. So we know that we have a freedom to contract. So individuals have a general right to choose with whom they enter into a contract, whether to contract or not, and which terms on which to contract. We then have the unfair contract terms legislation. It does continue to respect the freedom to contract, but it also seeks to prevent the abuse of standard form contracts which haven't been negotiated individually. So you still have that freedom, but there is protection that was introduced into the legislation for consumers and then which was later extended to small businesses. Just in terms of a bit of background, so in July 2010, the unfair contract terms provisions first came into effect, and only for particular business to consumer contracts involving individuals. By 2016, the provisions were expanded to small business contracts, and along came 9 November 2022, a bill was introduced, which became an act, which made some changes to the Competition and Consumer Act. And those changes were then expanded in recent changes on and from the 10th of November 2023. So we get this change where there's significant maximum penalties introduced, because previously the view was that yes, there was still unfair contract terms appearing in standard form contracts, and while the legislation made such terms void, there was a continuation of seeing these types of terms appear in contracts. And so we then get to a significant maximum penalty regime where you can see that the aim is to have more compliance and awareness with respect to unfair contract terms within standard form contracts. Just in terms of the legislative background, the Australian Consumer Law, which is scheduled to the Competition and Consumer Act, the relevant sections are 23 to 28. It applies to particular contracts for the supply of goods or services, or sale or grant of an interest in land. So just have a think about what are your common contracts. It's going to be your terms of trade. It's going to be, standard form building contracts. It's going to be franchise agreements. So there is a wide range of contracts that fall within the ambit of the types of contracts that you might enter into with respect to consumers. We also consumers and small businesses. We also see that in the ASIC Act, which deals with financial products or the supply of financial services, that's also captured within this concept of unfair contract terms. So what are the contracts that are actually at risk? So there are three important elements. We talk about a standard form contract. The contract must be a consumer contract or a small business contract, and the term must be unfair. So we want to just break down some of those elements in a little bit more detail. There are certain terms that are exceptions to the terms that may be deemed to be unfair. They're the type of terms that deal with the main subject matter of the contract. They're the terms that deal with the upfront price payable under a contract. And then there are some terms where they are either expressly permitted by law to be included into a contract, where because they have to be included or are taken to be included, they're an exception to the unfair contract terms regime. So let's talk about what is a consumer contract. Again, there are 3 criteria. So as I said, contract has to be for the supply of goods or services, sale or grant of an interest in land. So think about a lease, or a financial service or financial product, as I said, which that sits in the ASIC Act. It needs to be with an individual, and it's the acquisition or goods, services, or that interest which is wholly or predominantly for personal, domestic, or household use or consumption. And some examples are your, agreements with utilities, agreements in respect of perhaps you're building a residential property, you're leasing a residential property. So what is a small business contract then? So remember, the expansion of this regime to small businesses came a little bit later, but the definition, and you'll see that I have put 2 columns in there because there is a change in respect of pre-9 November 2023 and post-9 November 2023. So any contracts before we get to the 9th from the 9th of November, the definition of a small business was where one party is a business that employs fewer than 20 persons, and that includes your casuals employed on a regular and systematic basis, and upfront price payable under the contract doesn't exceed 300,000 or 1 million if the contract is for more than 12 months. So you'll see there's a monetary threshold in there before we get to, post 9 November 2023. It also is for the supply of goods, services, as I said, or that grant of interest in land. But the critical thing in that definition is the number of people employed and then this monetary threshold of an upfront price. Post 9 November 2023, under the ACL, you'll see the definition changes. So under the definition in the ACL, one party is a business that employs fewer than 100 persons and or has a turnover for the last income year of less than 10 million. So already you can see a substantial expansion in terms of what that captures as a small business. And that's quite a significant change. Under the ASIC Act, just by way of comparison, so if you're dealing in financial products and you've got a standard form contract, it retains the concept of the upfront price payable, but here it says upfront price payable does not exceed 5 million and one party employs fewer than 100 persons, and or again you've got this turnover for the last income year of less than 10 million. So you'll see that the monetary threshold it still sits in there in terms of the upfront price for financial contracts, but it's gone from really the from the ACL because that's an and or scenario in terms of employment of persons and income turnover of less than 10 million. So what contracts are excluded? There is a handful of contracts that are excluded from this regime, and you'll see that from the screen, they're things like constitutions of companies, shipping contracts, operating rules under the financial markets, and certain life insurance contracts. So there are a few things that are accepted, but they're quite limited in terms of scope. So we've talked about what's a consumer contract. We've talked about what is a small business contract. So let's unpick this idea of what is an unfair term. Okay, so we've got some 3 critical elements here. A term is unfair if it would cause a significant imbalance in the parties' rights and obligations, is not reasonably necessary to protect the legitimate business interests of the advantaged party, and advantage party is the one that bears the onus of proving that it's necessary. And finally, would it cause a detriment, financial or otherwise, to a party if it was applied or relied on? And look, it's a very interesting concept as to what would, when something is unfair. And remember, you're looking at it at the time you're either entering into these contracts, perhaps you're renewing the contract, or even if at a point in time, if you're varying your standard form contract. And if you think about what is unfair, this idea of significant imbalance, there was a case of Jetstar Airways and Free where they talked about what is significant. And there was a discussion about it meaning significant in magnitude or sufficiently large to be important. So it's not too distant from this, this concept of substantial, so substantial detriment. Only the court is going to be able to decide what is unfair. And in determining what is unfair, the court may take into account matters it thinks is relevant, but the legislation says it must take into account the following: the extent to which the term is transparent, and then the contract as a whole. So the court is looking at this contract or this particular term, perhaps that has been raised as unfair. They're not looking at it in isolation. They are looking at it in context of the whole contract, and you're looking for clauses that perhaps counterbalance the clause that is alleged to be unfair. And you're also looking at the form of the contract and the wording of the contract. So when we talk about transparency, we're talking about, is it written in reasonably plain English? Or do you sometimes have to read a clause and say, huh? And read it a couple of times to understand it, let alone us as perhaps lawyers. But for a consumer or a small business, you've got to think about the language in which it is expressed. Is it legible? I've seen contracts sometimes, a client says, oh, I just want to get all the terms on one page. So I'll do that by making the font really, really small. And to even read it, I have to make the font bigger so I can at least see it. So imagine how it would be for a client. Is it clear? Sorry, for a consumer or for a small business. Is it clear? Can it be easily read? Is it presented clearly? Are the terms readily available to a party affected by the term? That last one, let me give you an example, is where in the standard terms it says you're bound by our blah, blah, blah terms and conditions. And you're going, well, where is that? Is it readily able to be found? And it might be a reference to something sitting on a website or sitting in some other document. So that's another thing to consider on this issue of transparency. So let's talk about some examples of unfair terms. Crisco hampers. Sorry, before I get to that, I think I jumped ahead. Some examples of unfair terms. So some examples are terms that avoid or limit performance under a contract. The right to terminate a contract. So, for example, you might see a term in a contract that says only the business is able to, or the provider of the terms, or the supplier, or whatever you want to call them, is able to unilaterally terminate a contract. The right to renew a contract. Remember those, sometimes you see those terms where it automatically renews, and half the time, I don't know how many times a client has said, I didn't even realize that it renewed. And when you look at the term, it says something like, it's automatically reviewed unless you provide notice within, 60 days before the end of the term. So often people are not even aware that it has rolled over. The right to vary the contract. again, a supplier might have a term in there that gives them a unilateral right to just vary the contract. So from the other side, from the customer's side, what do they do if they don't agree with the variation, particularly if it's on something like price? Varying the upfront price. And remember, upfront price is the total value that somebody has to pay under the contract. So that ability to vary that price without the right of the other party to terminate if they don't agree with that. Varying the characteristics of the goods and services, determining whether the contract has actually been breached, limiting your liability for something your agents or your contractors do. And then sometimes the right to assign the contract to the detriment of the other party without the other party's consent. So there are a few things in there that can cause, well, it kind of flags some of these typical terms that may fall within the ambit of the unfair contract terms regime. Bike card was an example of a case where it was a 2013 case, so it was unreported, but it was the first legal proceedings based exclusively on the unfair contract terms provisions of the Australian consumer law. And it was actually action brought by the ACCC. And the ACCC was successful in bringing this action. And this bike card was an internet service provider. And they had terms and conditions on their website. And a number of the terms were deemed to be, and the parties agreed that they were unfair contract terms. So there was a term in relation to unilateral variation of the price. There was an indemnity of bike card that the customer had to give in favour of bike card. And then there was unilateral termination. So you'll see that some of those common terms were at issue in this case. And the clauses were declared unfair because bike card could just vary the price under the existing contract, didn't have to, there was no ability for the customer to terminate if they didn't agree with the price. So imagine if that price had substantially increased from what was first understood to be the upfront price under that contract. And if you don't agree with it, there was no right to terminate. There was an exclusion of liability for bike card while giving a bike card a virtually unlimited indemnity. Now, often customers will say, why are we giving an indemnity to our supplier? And I think the question when you come to indemnities is an interesting one, because is it actually really necessary to be in there? What does it actually give you? There was also the term that allowed bike card to just terminate the contract at any time with or without cause or reason. The court found that those terms created significant imbalance in the parties' rights and obligations. They also came to the view that they weren't reasonably necessary to protect the legitimate business interests of bike card. And they also took the view that it would cause financial detriment to a consumer if it was relied upon. I think that I remember reading a case that said a useful way to assess the impact of a particular term on the parties' rights and obligations is to consider what that contract would be like, or the impact of that contract without that particular term. Consider it with the term, consider it without the term. And that gives you a bit of a feel for whether it is absolutely necessary to protect a legitimate business interest. Crisco hampers, this was also an interesting case. So Crisco, and I don't know if you remember the Crisco hampers. I certainly remember the ads on TV where you put away money during the year towards, the Christmas dinner, which is probably an opportune discussion as we head towards Christmas. But they had what they called the Head Start plan. So your direct debit payments will continue until your order is fully paid, no later than, you see this goes back to 2014. And then after that date, a Head Start plan will be created for you and direct debit payments will continue accordingly. So the Head Start plan allows you to make payments towards next year's order while giving you time to decide exactly which products you want. We will write to you to confirm your Head Start plan payments prior to commencing your direct debits. Your Head Start plan is fully refundable at no cost to you should you change your mind. Okay. The problem with that Head Start plan arrangement, and again, this is ACCC taking some action against Crisco, and there were a couple of things. So there was a lack of transparency. So the lack of transparency in a contract may be a strong indication that as to the existence of a significant imbalance in the rights and obligations of the parties under the contract. The other thing that was an issue in this case was it wasn't plain language, it wasn't really legible, wasn't presented clearly, and it referred to terms that weren't readily available to the consumer. So there were a few issues there, and that's where you see the court looking at these terms in the context of the contract as a whole. And remember, we talked about the lack of transparency. So this Head Start term, it wasn't totally lacking in transparency, but the court said, look, the language wasn't really plain. It didn't identify the amounts that would be direct debited. There was a bit of use of ambiguous language. There was no explanation how to even cancel the Head Start plan. So the court said, look, it really could have been presented better. They were looking at the font size. Remember, we talked about the font size, and they were comparing it to, if you look at the heading and other clauses, the location of where that Head Start term sat, the colours used, and the location of opt-out, which was not contained in the terms and conditions. And consumers were required to opt out in order to avoid having to having these further payments automatically deducted after Crisco, by Crisco after their lay-by had been fully paid. There is an extract, which I've just put on the screen here. This is an extract from the actual judgment, and it gives you a bit of a flavour in terms of the size of the font, the colour, and you go, what's the significance of the colour? The significance of the colour is when you have a red box and white writing, or you have, this yellow, it makes it sometimes hard to read. So again, this is not the be all and end all, but you are looking at something in the context of a whole. You're also looking at clauses where you're going, okay, on its face, this particular clause may look unfair, but are there other clauses that counterbalance it? For example, if I vary a price or have the right to vary a price, what right does the consumer have or the small business have to negotiate, terminate? Are there any advantages for the consumer in terms of, is there a maximum capped price? So you're looking for clauses that counterbalance. In Crisco, the court said, look, what you have under the legislation and under some of these cases is a very broad evaluative criteria. It's not possible to kind of state with precision or have a universal test for when it will apply and when it won't apply. And this comes back to this idea that you have to look at a contract within context. So, as I said, you're looking at a term in one area of the contract that might in fact be counterbalanced by additional benefits conferred on that party in other areas of the contract. I am going to now hand you over to Karen. And Karen Wong is a senior associate in the commercial team. And she's going to talk us through some examples of how these terms may operate in practice.
Okay, thank you, Rebecca, and good morning, everyone. So I'm just going to go to the next slide. Thank you. So in this portion of the presentation, I'd really like to just run you through a couple of case studies so that we can see in practice how the courts have applied the unfair contracts terms regime. I'll also be discussing the introduction of the new penalties regime, as well as an expansion of the court's powers to address any breaches. And then I'll round up by running through just some practical tips for you to keep in mind when you are looking at your own standard form contracts, just to ensure that they are compliant with the unfair contracts regime. Okay, so the first case study I'd like to run through with you is that of the ACCC and Fujifilm. So in October of 2020, the ACCC commenced proceedings against Fujifilm, alleging that a number of terms in its standard form contracts were unfair, following complaints that had been made to the ACCC by small businesses. Now, in August of 2022, the Federal Court declared that 38 contract terms used in Fujifilm's standard form contracts with thousands of small businesses were unfair and void. The court orders made, they applied to 11 different types of standard form contracts that had been utilised by Fujifilm in its business in respect of printers and software licenses with its customers. You can see on this slide some examples of the types of terms that the Federal Court did declare unfair in this case. And we've got, for example, the first item there being unilateral variation terms. Now, these were terms which allowed Fuji to unilaterally vary terms of the contract, and these included terms contained in documents other than the actual contract signed with the customer. The standard form contracts also contained automatic renewal terms, and these allowed Fujifilm to renew the contract for a further period unless the customer cancelled the contract within a prescribed time period before the end of the then relevant contract term. There were also terms limiting Fujifilm's liability without corresponding rights for their customer. There were also disproportionate termination terms. And what this did was those terms allowed Fujifilm to terminate the contract in a much broader range of circumstances than the customer was actually allowed to terminate the contract. The customer was also charged excessive exit fees if they wished to terminate the contract. And there were also unfair payment terms, and these required the customer to pay Fujifilm for licensed software, irrespective of whether Fujifilm had actually delivered that software or not. Now, under the terms of the court orders, Fujifilm was required to contact its customers who were a party to the relevant contracts. They were required to also make those customers aware of the court orders that had been made against Fujifilm in this case. Fujifilm agreed with the court to implement a compliance program within its business, and it also agreed to pay $250,000 towards the ACCC's costs. The next case study I would like to take a look at is that of the ACCC and Motolo Group. Now, in these proceedings, the Federal Court declared that certain terms of contracts between Motolo Group, who was Australia's largest potato wholesaler, and contracts it had entered with potato growers, between December of 2016 and February of 2018 were unfair contract terms and thus void. Now, in this case, Motolo was ordered to pay a financial penalty of $240,000 for breaches of the Horticulture Code of Conduct in relation to 19 contracts that it had entered with potato growers. Again, just running through some examples of the unfair contract terms in this case, they included terms where Motolo was able to unilaterally determine or vary the price that it paid its farmers for potatoes. There were also terms where Motolo was able to unilaterally declare that potatoes were wastage without including a proper mechanism for review of whether or not potatoes were in fact wastage under that contract. They also included terms which prevented farmers from selling potatoes to alternative purchasers. There were also unfair terms which prevented farmers from essentially selling their own land unless the prospective purchaser of that land entered into an exclusive potato farming agreement with Motolo. Now, in this case, in addition to the orders that were made by the court, Motolo did provide the ACCC with an enforceable undertaking, and attached to that undertaking was a form of revised contract with its potato growers. And as part of the undertaking provided, Motolo agreed that it would contract with potato growers only on terms that were no less favourable than the form of the revised contract that was attached to the undertaking. So, as Rebecca mentioned earlier, only a court or a tribunal can determine or decide the question of whether a particular term in a contract is fair or not. In making that decision, the court does need to consider the matters that are listed on this slide. And just by way of recap, because Rebecca did run through the test of unfairness earlier. So the three tests of unfairness are, does the term cause a significant imbalance in the rights and obligations of the parties? Is the term reasonably necessary to protect the legitimate interests of the party that is advantaged by the term? Now, remember here, the party that seeks to rely on the term is the one that bears the onus of proof in showing that it is reasonably necessary to protect their interests. And the final test of unfairness is, would that term cause detriment, whether that detriment is financial or otherwise, if that term was applied or relied on by a party? Further, the court will also look at how was the term expressed in the contract. Again, for example, was the relevant term hidden in fine print, or was it hidden at the back of the contract in a schedule attached to the contract? What was the type of language used in respect of the term? Was the term expressed in complex or technical language? Were the words used in the contract term ambiguous or contradictory so that you did have to read the relevant term a number of times in order to understand what it was actually trying to say? And again, really what is, I guess the final point here is really what I want to emphasise is you cannot look at an unfair term or a potentially unfair term in isolation. You really need to be looking at it in the context of the contract as a whole. What we would need to be looking at is, for example, whilst an unfair term in isolation, taken in that context, may seem unfair, it may not be unfair in another context. And in the same vein, just because a court has decided in one particular case that a particular term is fair, that doesn't necessarily mean that that same term will then be fair in another case. Again, it really depends on looking at the contract as a whole. What are the other terms in the contract? Are there perhaps counterbalancing terms that offset the impact or the detriment of that particular term? Now, in considering the contract as a whole, the court does often need to do a bit of a balancing act. So what they're trying to do is they're balancing the legitimate interests, the legitimate business interests, of one party against the detriment that the potentially unfair term would cause to the other party if it were enforced. So on this slide here, I'd really just like to run through some of these practical tips for you to keep in mind when you are looking at your own standard form contracts and just checking for compliance with this regime. So firstly, it is necessary to perhaps look at both sides. So if you think that a particular term is reasonably necessary to protect your legitimate interests, perhaps consider the term from the other party's point of view and how that term would be perceived by them, being the receiving party, if you like, or the party that would experience the effect or the impact of that term. Perhaps include some counterbalancing terms. So whilst many businesses do include terms that allow them to make unilateral changes to a contract. So, for example, to the scope of the services being offered or the price to be paid for those services, it is worthwhile keeping in mind that these terms are often used by businesses as a form of risk management, if you like, and in order to keep their costs low. You can imagine the scenario that would arise that if businesses were required to separately negotiate with their customers each and every time that they wanted to change a term, that this would naturally increase costs, which may necessarily then have to be passed on to their customer. Now, in those circumstances, the court may consider that risk management and minimisation of costs would be a legitimate business interest. However, again, this is always going to depend on the particular circumstances that are being presented to the court. So for that reason, if your standard form contract does include unilateral rights, consider how the possible detrimental effect of that term could be minimised. So for example, in your standard contract, are you required to provide advance notice to your customer ahead of that change being implemented? Is the customer permitted to exit the contract without penalty? Another point on this slide is try to avoid the use of broad terms. And what we mean by that is ensure that the terms are only as broad as reasonably necessary, again, to protect your business's legitimate interests. So Rebecca again touched on the use of indemnities in contracts, which is very common, and we've certainly seen a lot of indemnities used in contracts that we've looked at for our clients. But ask yourself whether the indemnity is strictly necessary. Though they are really nice to have, especially if you're the party receiving the benefit of the indemnity, if they are one-sided or they're drafted so broadly to exclude every type of conceivable loss that the business could suffer, it could be argued that the indemnity does go further than what is reasonably necessary to protect your business interests. Perhaps by way of counterbalancing the effect of the indemnity, could you perhaps make the indemnity operate both ways so that it's a mutual indemnity? Could you narrow the operation of the indemnity so that it only applies to very specified and specific types of loss? Is there a requirement for a party to mitigate their loss before then seeking to rely on the indemnity? One point that isn't mentioned on this slide, but I did just want to raise it, also ensure that in your standard form contracts that you are meeting your obligations under the Australian consumer law. And what I mean by that is avoid having terms in your contracts that seek to avoid your business's obligations under the ACL. So, for example, terms that limit your customer's consumer guarantee rights, or terms that seek to disclaim any representations that your business may have made outside of the contract. Is the term clear, easy to read? So again, using clear and simple language in your contracts. Perhaps using words such as referring, when you're referring to the customer, use the word you and we when referring to yourself as the business. Again, look at your font size. Again, as Rebecca mentioned, we have seen examples of contracts where the font has been so tiny that just from the outset, it's already creating that lack of transparency from your customer's perspective. Another way to address this issue of transparency is that it is a good idea to bring key terms to your customer's attention. And one way of doing this is perhaps going through your contract, identifying the key terms that potentially may place more of an onerous obligation on your customer, and then maybe shifting or identifying those key terms to the beginning of the contract, or perhaps even highlighting the relevant terms, perhaps in bold, in the body of the contract. So there are a number of ways to address these requirements. There's no one rule fits all. It really is what works with your business, provided you do have these key requirements top of mind in your contracts.
And I was just going to say, on that question about transparency, there are some terms that are inherently unfair, and by bringing terms, when we talk about bringing it to the customer's attention, we know that in New South Wales, for example, under the Fair Trading Act, when you're providing goods or services, there is an obligation to bring to the attention any terms that are materially prejudicial to a consumer's attention. But if the clause is inherently unfair, just not having anything to balance it, but just bringing it to the attention of the client, the customer, in and of itself, it won't be sufficient. So just bear that in mind when you're looking at those terms and the question of transparency.
Thanks, Rebecca. So just moving on now to the introduction of this new penalty regime that came into effect on and from 9th of November of this year. Now, what this means is that on and from 9th of November, parties are now prohibited from proposing, using or relying on unfair terms in a standard form contract. And what is really important to keep in mind is that this prohibition can actually be contravened multiple times within the same contract. So accompanying this is the introduction of financial penalties for offending businesses and individuals. These changes apply to standard form contracts which are made or renewed on and from 9th of November, and also to a term of a standard form contract that is varied or added on and from 9th of November. And what I just wanted to point out is that prior to 9th of November, the position was that if you did have an unfair contract term included in your standard form contract, the effect of that was the relevant term was void and unenforceable if you tried to rely on it. However, now with the introduction of this new penalty regime, the inclusion of an unfair term is actually illegal, and it can attract quite significant financial penalties for the relevant business or individual. The court also has additional powers available to it to address breaches. And what this does, it gives the court more discretion in deciding what an appropriate remedy would be for that particular scenario. And I'll be discussing that in the next couple of slides. Now, what you can see on this slide is the magnitude of the maximum penalties that can be imposed by a court if the unfair contract term prohibition is contravened. What we should note is, again, that these penalties apply both under the ACL and also under the ASIC Act for those businesses that do provide financial goods or services. Now, moving on specifically to the types of financial penalties that can be imposed. In respect of businesses, it can be up to $50 million for each unfair term in the contract. And it's for that reason I made that note earlier that it is possible to contravene this regime multiple times in respect of the same contract. Alternatively, the court can look at 3 times the value of the benefit obtained from the contravening conduct if the court is actually able to determine the value of the benefit. However, if the court is unable to determine the value, then they'll look at 30% of the adjusted turnover during the period in which the business engaged in the relevant conduct. In regards to individuals who are found to have contravened the unfair contract terms regime, the maximum financial penalty there is $2.5 million. And what I would like to just note here, just to give you some perspective, we did look at the Fujifilm case study earlier, and just to give you an idea of the numbers involved, if Fujifilm had contravened the unfair contract terms provisions today, it could have faced maximum penalties of up to $50 million in respect of each unfair term in its contracts, which would have totaled a cost of approximately $1.9 billion. So I think that really just gives us some perspective about the importance of really just ensuring that when we are again reviewing our standard form contracts to make sure that they are compliant. Because again, those numbers are quite significant, putting it lightly. What I'd like to move on now in this next part is just looking at the expanded powers of the court to address breaches. What they now can do is that if the court finds that a contract does contain one or more unfair contract terms, the court is able to void, vary, or refuse to enforce part or all of the relevant contract to prevent loss or damage. They are also to prevent a term that is the same or substantially similar to a term that has been declared unfair from being included in any future standard form contracts. From the 9th of November, the court does not need to consider if the proposed order will actually remedy the loss or damage that's been suffered. Just continuing on with this point of the court's broadened powers, they do also have additional injunctive powers, and these include restraining a person from entering into any future contract that contains a term that is the same or similar in effect to a term that has been declared unfair, or they can also restrain a person from applying or relying on a term in any existing contract that is the same or similar in effect to a term that has been declared unfair, whether or not that particular contract is actually before the court. Okay, so that's all I had to cover in my part of the presentation. So unless Rebecca had anything to add.
Yeah, look, I just wanted to talk about, you're probably sitting there saying, well, what is a standard form contract? And you'll see the elements of standard form, and I think it's something that you use all the time. You roll it out to your customers. There is that element of here it is, take it or leave it. There's not a substantial opportunity to negotiate the terms, and we're not talking about changing or amending minor terms. And often, I mean, that's just, as Karen said, that's just the nature of standard form, is because it is cost effective and you are rolling it out multiple times to a range of customers. But they're the type of elements of what is standard form that is going to fall within the ambit of the unfair contract terms regime. So even if you have a term, for example, that says the parties agreed that the customer has an opportunity to negotiate the terms, that in itself is not going to get you off the hook. And that was actually, especially as from the 9th of November, that just having that sentence in your standard terms, you're looking at the substance and the real opportunity that a party had to negotiate on a substantive element of the contract or substantive elements of the contract rather than minor amendments. So when you turn your mind to it, there are a number of terms that often, are presented to customers, and often customers think, well, I don't really have the opportunity to go back and negotiate on this. Some do, and that's really good. But bear in mind where the onus and where the presumptions in relation to these contracts sit. So there is a presumption that something is an unfair contract term. There might be a presumption that, something exists, and the party saying, no, it's not an unfair contract term, or that it reasonably is necessary to protect our business interests, that is the party that bears the onus of proving this. So there are some contracts by its nature that it is necessary to have that term in there, but you need to be able to justify it. So, for example, might be a breach of confidentiality. And it might be something that, the liability extends to, consequential loss. Now, that might, or confidentiality, or even a data breach, that might actually be justifiable. But you need to say why, because what is the loss that we would suffer if, there was a breach of confidentiality, or, data was a release of personal information or something like that. Think about a franchise agreement. Now, some of the elements that, or the ability that the franchisor needs to have might be necessary in the context of a franchise agreement. So bear in mind, as the party putting forward these terms, you bear the onus of proof. And so really think through how it will actually sit in the context of the contract as a whole, and whether it's something you can say, well, this was necessary in this context because. So that's just something else just to bear in mind. Sometimes just by putting in phrases like a party can do this acting reasonably, that itself may not be enough. So you have to actually look at the substance of the contract, of the term in question. And what you're doing, remember back at the start of this, I said, the court talks about assessing the impact of that term if it's in the contract or if it's not in the contract. So if you took it out, does it make much difference? If it's in the contract, what is the effect on me as a small business or a consumer? So it is very much a balancing act in that respect. You're looking at things going, well, okay, if we put that in there, what's the flip side for that customer? Are they just stuck in this contract with no say? And here I am varying things, or have this ability. Indemnities, as I said, are an interesting one, because often the question is it actually necessary for us to have a customer provide this unlimited indemnity in the event they do something? And the indemnity is really, often indemnities are kind of put into contracts because, and I'm not saying that in every scenario an indemnity is not justified, but you really have to think about, you have to be careful with the wording, and you have to say, well, if we don't have an indemnity in there and we don't, what happens if there is a breach of the contract by a customer? So, we'd have to rely on our rights to sue that customer and seek any damages, and prove that it arose from the loss. And, I don't have to prove that I took steps to mitigate that loss. So, as I said, everything has to be looked at in the context of the agreement as a whole and the type of agreement. And if you're the party that is bearing that onus, I would be able to, sometimes we have clients go, no, we have to have that clause in there. And we often say, well, why is that? What does it actually add to the contract? And, I think sometimes clients take a step back and go, oh, actually, no, we don't really need it. Or, look, to be fair, and this is what it's all about, they go, to be fair then, let's make it mutual, or let's add this in there. So already a lot of our clients are thinking in terms of this counterbalancing argument. And you kind of see this coming out of a lot of these cases. And, I remember one of the earliest cases was the J.J. Richards, the big industrial waste bins. And one of the earlier, there were a number of terms in those standard form contracts that were found to be unfair, but the one that always stuck in my mind is the auto renewal clause. And and I even remember back in the day, before this kind of came into play, clients were going, I'm stuck in this contract, it just auto renewed, like we don't have this right to actually terminate. And so it really is looking at, we've seen kind of these terms from both sides of the fence, where we're asked for a client to go, by a client, okay, can you have a look at our standard form? Can you advise us? And now that I think this is a lot of what we're getting at the moment. Can you give us some guidance? Can you give us some advice in relation to whether you think some of these terms are unfair? We also get it from the other side, where clients are going, can you look at this? We're being asked to enter into this contract. Can you give us some guidance on whether from our perspective, this should be in here. And in the same breath, we've had, we've had to write back to other parties on behalf of our clients saying this contract is an unfair term. And we make that allegation. So remember, it's not for us to decide. It's for a court or a tribunal to make that determination. But in raising it, it does take a party, it forces them to take a step back and go, okay, well, yeah, look, maybe. It makes them more open to a negotiation. And so the critical time to do this is when you're entering into these contracts, or whether you might be renewing them, you might be seeking to vary them. That's the time to do it. And so what this whole regime seeks to do is redress that balance of power between the parties, because obviously when you're given a standard form contract, there is that imbalance to begin with, because often it's a take it or leave it scenario. And customers think that there's not a lot of ability to negotiate. Having said that, I've had customers and clients come to us and go, we got this back from this customer, and they've taken a red pen to it, metaphorically, and put a line through this clause and this clause and this clause. And it does force that client to take a step back and going, well, if this clause wasn't in the contract, what would this contract look like? Does it actually cause an issue for us? And if so, why does it cause an issue for us? And even with the giving of indemnities, often that's a matter, and you might let me know what you think, Karen, where we go to clients, what insurance do you have? By giving an indemnity in the first place, how does it affect your insurance policy? And if the indemnity wasn't in there, would you still have adequate insurance if a claim was made against you? So that's the other aspect just to be aware of, is what does your insurance policy say? So I think that's also an interesting aspect to it. So I think the moral of this story is there are many standard form contracts that are of different types. And as I mentioned before, franchises, lease agreements, building contracts, where those terms are already worked out and in place. I think what this will cause, particularly because of the penalty regime that is now in play and the extensive power of a court to actually really scrutinise some of these terms, and for the ACCC also, they get enough complaints, they're going to take action, is that it now puts a lot of these terms in these contracts under the microscope to really consider, should these terms be in there? And if you haven't done it before, now's an opportune time to actually pull out your standard form contracts and actually have a look at them. And sometimes I've got a client who is entering into a financial facility with a bank. And one of the things the bank wants to see is this standard form contract, interestingly enough. And they also determine, before you can amend any terms of your standard form contracts, you'll need, the bank's consent. So that's another interesting aspect of it in terms of, your financier comes into play.
Lots of things to keep in mind outside of the contract.
We have a question that's come through. How does one easily determine if the other party is a small business?
So that was something that Rebecca did touch on earlier in the presentation. So again, there's now 2 criteria under the regime. So the first is you look at the number of employees in the customer or the other side, and the threshold now is 100. Is it 100 and under or less than 100? Sorry, just remind. Less than 100 employees, thank you. Or you're looking at the turnover of the business in the previous year. Look, I would think that in respect of identifying perhaps a number of employees, and this is just something maybe that I would do, I would just maybe do a quick Google search if you're not familiar with that particular customer, or even you could ask them.
And credit application.
Maybe that could be one of the questions.
Yeah, so
Yeah.
exactly. So you know how like when you have your standard form credit application, you've got in there, you know, I've seen people say, what's your annual turnover? You could add it to what number of you know, employees. Bear in mind, casuals, unless they're regularly and systematically engaged, they won't fall within the numbering of the employees, but it could be a question that you put in your
and I think
credit app.
Yeah, so that would be something procedurally that you could introduce into your business, and that might be an easy way of capturing that relevant information at the outset, along with all the other information that you're capturing about your customers well when you sign them up. Do we have any other questions that have come through? So that it's not coming through on my screen.
We will, just to let you know, we will have the presentation emailed to our attendees. So just in case you were furiously
trying to take notes,
because there's a bit in there. So will circulate the presentation. We also put out an article recently on the actual changes that came into effect from the 9th of November. So that's on our website, but we could probably circulate a copy of that as well. That'll give you a good contrast between the two. I think we're pretty much smack on time. So we'd like to thank you for your attendance today. We hope that the information provided was useful. Please feel free to reach out if you have any very specific questions related to your contracts. We're here to help. But thank you again for your attendance.
Thank you, everyone.
Bye-bye.